Talk about technology. You mentioned in the Jones opinion on GPS tracking in the heat lamp case, Kylo, in the context of originalism. Technology cases provide thorny issues for the court, obviously. You've dealt with some on your own, including the review of Colorado's retail tattletale law, DMA versus Brawl. How should judges approach issues of new technology as it applies to litigation?
Well, Senator, in the first two cases, you're dealing with the question of an unreasonable search and seizure. What's a search? In the Jones case, is it a search to attach a GPS tracking device onto a car? Where does the government, if it is a search, perhaps the government will need a warrant to do that. If it's not a search, it can just do it willy-nilly. And so you have to ask yourself, well, what's a search? Is that a search? And to do that, the court went back and looked at the law of trespass, as it was at the time of the founding, and concluded that that would be what's called a trespass to chattels, a trespass on your private property, on your, not a physical property, personal property. And that would qualify as a search or a trespass, a property right violation at the time of the founding. And concluded that when we're interpreting the term an unreasonable search, what's a search for the Fourth Amendment, that the Constitution of the United States today can't be less protective now of the people's liberties than the common law understanding was at the time of the founding. That's the way the court reasoned in that case, using existing legal principles to address a new technology. And that's the sort of thing judges do.
How should judges familiarize themselves with new technology? Do we get to leave that to law clerks like we often leave it to staffers to understand new technologies? How important is it?
These are areas where Congress has a role too, respectfully, Senator. New technologies challenge us, all of us. And what's a reasonable search? Guidance from Congress is helpful in that regard. And in fact, I think Justice Alito wrote a separate opinion in the Jones case inviting Congress's action in this kind of area where we're dealing with new technologies, precisely because of the challenge of trying to address vastly new circumstances, new technologies that we haven't seen before.
You're right. I mean, we deal with that issue here all the time, trying to balance security versus privacy issues. We think that we have it done or balanced, and then new technology comes and upsets it. And I'm sure it's the same for the court.